Hello friends, welcome back to my channel. Welcome to another new segment. Today we will be discussing about the anti-defection law as on Wednesday 22nd June, Maharashtra's ruling party Shiv Sena called a meeting of all MLAs in Mumbai, and some of its legislatures have aligned themselves with the party's rebel leader Eknath Shinde and are camping in Guwahati. So the party has warned its MLAs that their absence from meeting would lead to the presumption they wanted to leave the political party, and this would therefore lead to action against them under the anti-defection law. So let's discuss what is the issue. The practice of politicians deserting parties just ahead of elections is not unusual, and every time there are defections, the anti-defection law, which penalizes the individual lawmakers for switching parties, comes into picture. If we talk about its relevance, the 10th schedule of the Indian Constitution contains the anti-defection law, which is popularly known as anti-defection law, as I said. So it specifies the circumstances under which changing of political parties by legislatures invites actions under the law. It was added to the Constitution by the 52nd Constitutional Amendment Act. It includes situations in which an independent MLA too joins a party after the election. The law covers three scenarios with respect to shifting of political parties by an MP or an MLA. These include: first, when a member elected on the ticket of a political party voluntarily gives up membership of such a party or votes in the house against the wishes of party. Second, when a legislature who has won his or her seat as an independent candidate joins a political party after the election. In the above two cases, the legislature loses the seat in the legislature on changing or joining the party. Now it relates to the nominated MPs also. In their case, the law gives them 6 months to join a political party after being nominated. If they join a party after such a time, they stand to lose their seat in the house. Now, if we talk about the matters related to disqualification, under the anti-defection law, the power to decide the disqualification of an MP or an MLA rests with the presiding officer of the legislature. The law does not specify a time frame in which such a decision has to be made. Last year, Supreme Court observed that anti-defection cases should be decided by speakers in 3 months' time. However, legislatures may change their party without the risk of disqualification in certain circumstances. These are some exceptions. The law allows the party to merge with or into another party, provided that at least 2/3 of its legislatures are in favor of the merger. On being elected as the presiding officer of the House, if the member voluntarily gives up the membership of his party or rejoins it after he ceases to hold that office, he won't be disqualified. Now, if we talk about the loopholes in this law, those against this law says that voters elects individuals in the election and not parties, and hence the anti-defection law is infructuous. Now, the question is, can the courts intervene in this? Yes, the courts have in certain cases intervened in the workings of the legislature. So in 1992, a 5-judge constitutional bench of Supreme Court held that the anti-defection law proceedings before the speaker are akin to a tribunal and thus can be placed under the judicial review. In January 2020, the Supreme Court asked the Parliament to amend the Constitution to strip Legislative Assembly speakers of their exclusive power to decide whether legislatures should be disqualified or not under the anti-defection law. In March 2020, the Supreme Court removed the Manipur minister Shyam Kumar Singh, against whom disqualification petitioners were pending before the speaker since 2017, from the state cabinet and restrained him from entering the legislative assembly till further orders. So this is all about the anti-defection law, and thanks for watching this video.